Hi, I'm Brett Cenkus. I'm an M&A attorney and an M&A broker. And today we're talking about what does it cost to hire an M&A attorney. So if you've got a general question later on, or you like this video, want to comment about it in some manner, you can do that below. If you want to book a call with me, you can get a link below to clarity.fm, which is a service that I take calls on. And let's get into it. Okay. What does it cost to hire an M&A lawyer? So, the classic saying is, how long is the answer to the question is the same as how long is a piece of string, right? Which is to say, who knows? It depends. There is no easy answer. And that is true to some extent. However, we're going to try and give you some actual concrete information here that you can use. And this is for me and my practice. I'm going to say a little bit about other practices, but at least you've got something to go on out of my world. Okay, so let's talk about a hypothetical $2 to $4 million M&A deal. We're going to know nothing else. Okay. I built $560 an hour. I've got an associated bills at $390 an hour and a paralegal bills at $190 an hour. We will quote a client $10,000 to $15,000 as a just kind of broad range if we know nothing else about the deal. Okay. That's going to be a pretty good range and capture, the 80% of our sort of small M&A deals that are structured as asset purchases, which most are. Okay. That is going to be the lower end of the spectrum. And there are deals where it comes in a little bit lower, and there are deals where it comes in higher. Right. And I'll try to explain a little bit about why that is the case. We do very little on fixed fee. If I was going to flat fee a deal that I thought was going to be 10 to 15, I'd ask you for 25 to 30, because it's just the nature of what happens when the meter stops running. So we just haven't been able to figure out how to make fixed fees work. Big Law does them, but they charge a ton. I mean, they might charge you $250,000 for that deal. Really. If it doesn't go down, they might even do it on contingency. If that's what they would charge you, not a flat fee, no matter if it goes down or not. But if it closes, that was my best. Well, actually, I've got data points around that. For a relatively small deal, $5 million deal, that's a lot of money. Now, if it doesn't close, you're not paying it in this case. If they flat feed a deal that whether it closes or not, they probably 100, 150. I mean, it's a lot more. Now, the way they're making that work is that, it's just the nature of, number one, their costs are going to be more over there because they have more people on the deal and they bill at higher rates. But again, let's get back to me and my world. It's an asset purchase agreement. 10 to 15 is a fairly good range. If we represent the buyer, we would guide towards the lower end of the range. If we represent the seller, the higher end of the range. The reason for that is that most of what goes into a purchase or merger agreement is going to be to protect the buyer. The buyer is generally going to write that agreement, and I'll get into that in a minute. But because there's so much here that is to protect the buyer, what it means is there's risk after closing to our seller, and the seller needs to understand and appreciate that. And we need to navigate and negotiate all this wording to protect our sellers and inform our sellers. So the amount of conversation we have with sellers is greater over a purchase agreement than a buyer. Writing for a buyer, we write with a broad brush. We try to capture, the wording, and most lawyers are going to do this, the word's going to be very broad, and the seller's attorney's job is to narrow it down and have it make sense. You still have to disclose information. This isn't about writing it so that you don't have to tell them what's wrong. It's about appropriately sharing risk on the backside of the deal after closing. And so there's just more of that. There's more education of the seller. There's more conversations about what does this really mean. Oftentimes we have multiple sellers, owners, and they're all wanting to weigh in and get a perspective and on calls and think about things. So we just tend to have more time spent educating, informing, and strategizing on the seller side. So again, that would still that range is still a fairly good starting range. You just might sort of trend towards the lower end for buyers and the higher end for sellers. If the deal is not structured as an asset purchase, it's structured as a stock purchase or equity purchase, sale of LLC interests or partnership interests, or a merger agreement, it will be more. Probably $5,000 more, something like that. There's just a lot more that goes into the purchase agreement when we're not selling just assets. It's not a fundamentally totally different looking document, but there's things around, for example, the easy one to understand is that if someone's taking over your business, right, they're buying the stock and stepping into your shoes. They're not just buying all of the assets of your business, all of it separately and bringing into their business. They're going to take over your shares and step in. It means you owned the stuff. You're going to have to file a tax return for that year that the closing takes place. Well, you owned it for part of the year, and the buyer owns it for part of the year, and you've got to talk about and figure out and write up and agree on how that's going to be handled. Who's going to file the returns? Who has a right to contest the returns? There's a lot of things that go into a transition and overlap in those type of structures. Now, it isn't really a reason to choose one structure over the other. Not generally. There's drivers that are more important than the cost of the attorneys, and say that as someone who's collecting the money. But honestly, it's what it is. And if the stock deal makes the most sense and it's what the parties have agreed to, we deal with it that way. But there is more that goes into it. If we write the agreement, the purchase agreement, and generally the buyer will write the purchase agreement. So if we're representing the seller, we don't usually have a chance to do that, but sometimes we can make a play for it. It will inevitably be less money on the deal. I can guarantee it. Because we universally see one of two things out of buyer counsel. We see big law or experienced regional lawyers, M&A lawyers who know what they're doing and have good documents, but they tend to be exceedingly robust. The 40, 50-page purchase agreements, which makes sense for $20 million deals, $100 million deals. They don't make that much sense for $2 million deals. So we get a document, and oftentimes, it's just what they serve up, and it takes them less time to produce that than if they slim that thing way down. But it's going to take us a lot more time to work through it, inevitably. If we write the agreement on your average $2 million deal, you're going to get a 10-page document. It's going to be pretty darn streamlined, especially even more streamlined if we represent the seller, because remember what I said, 80% or something of what goes into a purchase agreement is to protect the buyer. So if we're representing the seller, we're not trying to serve up something that's ridiculous, but we're not doing the buyer's work for them. So there's going to be a little bit less meat on the bone. But even when we represent the buyer, we have a real practical understanding about sort of cost and what makes sense. Ultimately, what you're paying for when you hire an M&A attorney is a type of insurance, right? If the deal is clear and everything works out perfectly, you hope you never dust off the purchase agreement, the merger agreement. However, sometimes things go wrong, and when you do, you'll probably wish you bought even more insurance. We're trying to figure out up front what insurance you need to buy. And it's just way more stuff than you need to handle if you got 30 pages for a $2 million deal. It just is. Lawyers have a way, and no, not big law has great lawyers, but they have trouble modernizing their wording. It works. You can ultimately understand it. Sometimes you have to be a lawyer to understand it, but the documents work. They're just, we say things 10 times that can be said very simply. And we've taken a lot of time over the years to make very streamlined starting forms and things. So we've got our standard go-tos for a $2 million deal. And again, that's going to be a 10-page kind of deal. It's going to be very, very streamlined. And the other thing we see, if we don't see a very robust agreement from a very good lawyer, is we see a short or sloppy agreement from a not great lawyer, or maybe I should say not an M&A lawyer. And that requires a lot of work to fix that document when we first get it. We would rather just scrap it and start with our starting point, but the politics and the stances of the parties, that's tough to do without throwing the other attorney under the bus. And so you've got to navigate these waters accordingly. So we're living often with a document that's just not covering over the issues as they should be covered. And then as we bring them up, we have to do we have to educate the other attorney. Again, I'm not talking incompetent attorneys. I'm just talking ones who don't know these waters really, really well. And so it's just a harder process, and that adds time. A big law is so that's me, $10,000 to $15,000. There's reasons. Again, you're not going to beat that by much if we're really lawyering that. There are things on the sell side. I didn't talk about. Disclosure schedules is sort of a kind of a heavy administrative lift that isn't included, and we are going to we are too busy to want to do anything that our clients can do. I mean it. If you can take it on, I don't want it. I'm happy to have you take it on. And disclosure schedules are one that our clients, if they're good at paperwork, can handle. When it falls to us, it adds time and it's going to add cost. And it's hard to predict that cost. There's a lot in this process that's sort of outside of our control, as I said. The ideal situation is, this just sounds so self-serving. I'm conscious of that. So save your comments or put them out, whatever. But if we write that purchase agreement, we know how to move these deals quickly. We can be really thoughtful about it. I've spent a career trying to figure out what really matters. And I've got a lot of perspective on this from the lawyer's seat and from the business person's seat. Does that really matter? What do we need to do here so we can plan accordingly? And so that range I gave you is a pretty good range. There are lawyers who are going to do your deal for less. I think you'll get less work and less value. Well, you'll get less work, but you'll get less value. I think we have a pretty good value position in terms of who we are as M&A lawyers. Big law, you're going to spend more. You're going to have good work. You will. They do good work. You're going to have more heavily staffed deals. This deal I'm describing to you, back in last time I practiced private practice at Big Law was almost 20 years ago. And we would have quoted out 30 to 40 grand on a flat rate. So I think probably that's $100,000 today, and that's not scatting where like the Am Law, like Big Law, the five biggest, one of the biggest corporate law firms in the world. They're not going to take a $2 or $5 billion deal probably, but you're going to have more, you're going to get a lot of work. Do you need it is the question, right? Can you afford it? Does it make sense in budget? All of this stuff comes back around to insurance, and you can over-insure, but you got to pick the right amount for you. So anyway, general questions, put them below. Specific questions, contact me on clarity.fm. I appreciate you watching today. Hope you enjoyed the video. Thank you.